What evidence is usually needed to prove a will is valid when someone alleges lack of mental capacity? Usually, the key evidence focuses on the signer's mental ability on the day the will was signed. The goal is to show the person understood three basic things: who their close family and likely beneficiaries were, what property they owned in a general sense, and that the document they were signing would control who gets that property at death. The most common proof comes from the two witnesses who watched the signing, especially what they observed about alertness, conversation, recognition of people, and whether the signer seemed to understand they were signing a will. The drafting attorney's notes and staff observations are also important because they can show what the signer said about their assets and intended beneficiaries, and whether the plan was consistent over time. Medical records close to the signing date often matter a lot too. Things like diagnoses, medications, cognitive testing, hospital notes, and whether the person was oriented and able to make decisions. Courts also consider specific, real-world observations from friends, neighbors, caregivers, and family members about how the person functioned around that time, plus documents that show everyday decision-making, like communications or banking activity. When needed, a qualified medical professional may give an opinion based on records about whether the person likely had capacity at the time of signing. Evidence closest in time to the signing date usually carries the most weight, and specific examples tend to matter more than general claims that someone was simply confused.